Yes, sir.
Good morning, Mr. Chief Justice.
Morning.
I'm Ron Davis from Winston-Salem, North Carolina. One of the things that our firm is grappling with is social media, and it impacts ethical obligations that we have. It impacts our client confidentiality issues. And I figure if we're probably grappling with those kind of issues, it's probably even more acute in the court system. I was just curious how the Supreme Court has dealt with this phenomena. I could have this image of one of your clerks tweeting from the Supreme Court about what's going on, and I was wondering if it was done on a justice-by-justice basis or if you had enacted certain policies on that area.
I sit down with incoming clerks at the beginning of the year, as soon as we get back, and go through a number of things they have to be aware of, and that's one of them. It's new. We tell them that they obviously shouldn't be tweeting about what they're doing, or whether they have, websites or whatever. And a lot of it is inadvertent. They kind of think, I'm working very hard on an opinion this week or getting ready for an argument. And, discerning people can kind of look at what they're saying and put two and two together and figure out maybe what their boss is doing and all that. So even unintentionally, they can sometimes reveal confidences, and, of course, that's very, very dangerous. So, I advise them just kind of put all that on hold. Now, I also appreciate it's a generational thing, and the idea of sort of not being connected in a particular way can be problematic for them. It's also a generational thing. It's not, I guess. It's not chronological age. Different members of the court are more adept at that than others. I don't think any of us have a Facebook page or tweet, whatever that is. But technology is making inroads. I mean, we find when we're traveling, it's easier to have some of us briefs on some of the products where you can have them electronically available than carrying them around. Different people have a different degree comfort level. So it is in the court and the courts in general. I think it's a challenge in a lot of areas that is just something we're going to have to deal with. It's not limited to that. The impact of the new technology on substantive law is really quite significant. Whether it's what does it mean in antitrust law to have new technology gateways that are different than we're used to. But that, too, is nothing new. I mean, you think of the Supreme Court's dealing with the wiretap cases when wiretaps were a new thing. The first decision says, well, of course that's not covered by the Fourth Amendment. What is that? And the court came to have some experience with it and reversed itself. So it's going to be a great challenge both in the substantive area and for many of us to try to keep up with the new technology that's just so very... It's one of the great things, again, with the law clerks. They come in, they know how all this stuff works and what it means, and they're a resource for kind of educating those of us who are a little bit behind the curve.
One of the things, the theme of the conference has been accessibility.